All right, so we've gone live. And hi, this is Abhyuday Agarwal, CEO and co-founder at LawSikho. We're going to discuss today 20 most common mistakes that beginners make while drafting and reviewing contracts. Okay, so I've invited all of you who are here in today's session to share with me what is your current, where do you stand with this topic? How many of you have drafted a contract earlier? Say yes. Like, if you've drafted it end to end, say yes. If you've drafted end to end one contract, say yes. If you've seen a contract, then say seen, SEEN, right? Seen. Okay. If you've drafted, you say drafted. Okay. Full contract. Okay. If you've proofread, then you write proofread. Only one word, proofread. Okay. Okay. So seen. Those who have seen, name the contract you've seen. Okay. Great. So, Pramita, Nimisha, which contracts you've seen? Anubhav, which contracts you've seen? Everybody who's seen a contract, see which ones you've seen. Is there anybody here who has drafted a contract? Say, I've drafted. Okay. Anybody who's proofread, say proofread. Okay. Super. So, Anubhav Gargs, you have seen EPC franchise and publishing license. Mukesh and seen a lease contract. Yes. No proofreading experience. Sudarshan. Got it. Okay, so today what we're going to do is, I'm going to keep the level a little basic because if there are experienced people, you've drafted lots of contracts or drafted more than 5 contracts, okay, even 5 contracts or more, you please let me know here. Okay, it'll be very helpful because I want to keep this session as relevant as possible, right, to all of you. So share that and then we start in full swing. I have a very interesting list of 20 points that you can keep in mind. Anubhav has drafted 17 contracts. That's good. Drafted or seen, Anubhav? You had said seen. Okay. Anubhav, for the others, Anubhav is currently studying our contract drafting course and is a law student in, I think, the second or third year right now and does a lot of freelance work. Okay. So I'm going to start with step 1 of what are the most common mistakes. So this is like a listicle, okay? List 1, 2, 3, 4, 5. Where am I sharing this from? So I have been coaching hundreds of people, hundreds of experienced lawyers, litigators who want to move to contracts, corporate people, in-house lawyers on different aspects of contract drafting. Okay. So corporate lawyers sometimes want to learn technology contracts. Company secretaries want to learn various kinds of corporate contracts and other general commercial contracts. Law students want to learn the basics of drafting from scratch. Even non-lawyers, a lot of procurement managers, HR managers, they want to learn how to review and understand contracts. So I've explored a lot of innovative ways in which one can teach somebody how to review and draft contracts. And I'm going to share some of the insights that I have discovered after teaching and reviewing contracts, real contracts also, and contracts made by first timers or beginners. Okay. um so, and I drafted my first commercial contract around in the 5th year. Okay, in the 5th year, when I helped a friend raise investment of about 50-60 lakhs from a foreign investor. That was the first time I drafted a commercial contract. After that, there have been tons of commercial contracts that I have drafted either for our own company or for LawSikho, or helped others draft, or created like a productified standard solution that lawyers can later customize. Okay, so this has I've done this over about 10 years now. Okay, so let's understand the first mistake that people make: not understanding the commercial purpose of the transaction. So what do you do when you get a contract? The first thing you will do is you will read it end to end, right? Now, if it is a 100-page contract, by the time you finish reading it end to end, 3-4 hours will pass. Mostly your brain's attention will go away. Correct? This happened with me in third year interning at AZB. I'm trying to read various syndicate finance loan agreements. Syndicate finance is basically foreign and Indian banks or multiple banks lending to a borrower, hundreds of crores. Okay, because the amount of money borrowed is huge. There are multiple lenders lending. There are other documents also along with the loan agreement that go with it. And what I am doing basically is trying to read it end to end, tearing my hair apart and not understanding everything. I understand one clause and then I lose the whole picture. Same thing happens with investment agreements. There are so many jargon related clauses, okay, in investment agreements that this happens. Now, jargon is a part of every kind of commercial deal. You must understand that no matter which sector, and jargon is specific to a particular sector. For example, a FIDIC or a construction contract, okay? A construction contract will have its own jargon. A power purchase agreement will have its own jargon. So there will be some generic clauses. There will be a lot of specific clauses common to only power purchase agreements. A franchisee agreement will have its own specific clauses. A shareholder share purchase share subscription agreement will have its own specific clauses. A loan agreement will have its own specific clauses. Not understanding that is going to be a problem. If you look at a lot of the books that are there, you will see that they are explaining various terms in a contract, taking it all together, like 50 terms of the contract, let's understand these clauses. But where a lot of this falls short is in explaining the sector specific jargon and the commercials. For example, what is an anti-dilution clause in a shareholders agreement? Okay, that is some. How does it protect an investor's rights? That is very important. Good Anubhav, escrow agreements have their own uh, requirement. Software escrows are different from regular escrows. Okay, an escrow such as what an Upwork would keep. Upwork, what it does is that if you are getting a freelance assignment, sometimes they allow a escrow feature where the money is kept with them. Okay, or you would have escrow agents in the banking finance industry or various industries. So escrow agent is a middleman and they will basically ensure that neither one party, like where a transaction has to be performed by both parties simultaneously, the risk is that if I perform my deal, you may back out later and I can't hold you to it. So the escrow agent ensures that both sides perform the deal simultaneously. Yeah, Vaibhav. Paytm also keeps payments on hold until the other side does its job. So not understanding the, now what did I mean here? So when you've not understood the sector specific jargon and you don't understand the commercial purpose of the transaction, then what will happen is that your drafting and review exercises will be incomplete. Okay. And by the way, when you work on a real contract, there is a lot of sector specific, there is a lot of contract business specific information that goes in. And it's not like this that when you get a civil suit or you get an arbitration matter, the client will give you certain facts, right? And you will say, okay, I want more facts. What happened now? What happened next? What happened next? And based on that, you will think and identify a strategy and a document to draft. Contract drafting work doesn't work like this. Client will say, this is the deal I'm thinking of, and then you will have to take two steps ahead and help the client figure out scenarios, figure out things. Okay, if you are basically the client's lawyer at the pre-contract stage, if they're going to give you work, that's what you have to do. Okay, if you're reviewing contracts as an intern also, at a law firm, for example, then at that time you have to understand the commercial purpose to be able to do your proofreading tasks properly. When I was doing an internship at like I was doing this at AZB in third year, fourth year, at that time what I realized was that when I couldn't understand the whole purpose of the transaction, my proofreading job wasn't happening properly. So I realized that I have to first understand the purpose. What do I mean by the purpose? Okay, purpose is not a one liner. Like if I say, what is the purpose of an investment agreement, okay, or a shareholders agreement, share subscription agreement? It allows an investor to invest into the company, but it protects certain rights of the founder. It protects certain interests of the founders. It protects certain interests of the investors. Which interests of the investors does it protect, and what are the clauses that do that? You should be able to understand literally on your fingertips. Okay, same for founders. What would a founder want when they negotiate with investors? What would a borrower want when it is negotiating with a bank? What would the bank want? What will be okay with one side? What will not be okay with it? Okay, so understanding this commercial purpose is very important. Under which circumstances can the bank say that you can't draw the money anymore? I've approved the loan, but now this happened and you are ineligible from drawing, or drawing meaning borrowing the loan. Giving you example, okay? So commercials is very important. Basically, who gets what. So one party will earn and one party will pay for certain thing that is done or not done. Whether product, service, anything can be there. Okay. So commercials is very important. Subject matter. Okay. What is the actual service, what is the property being transferred, is there real estate, immovable property, is there a trademark license. Here a lot of statutory aspects also come in case of subject matter. Okay, so that gets triggered. Parties, people don't have a clue about. Big contracts have too many parties, so you can't figure out who's doing what, becomes very unclear. Right now it's very easy, no? In a rent agreement or in an NDA you will have two parties most of the times. But when you have a shareholders agreement, you have a loan agreement, you will go mad. There's like this party security trustee, this one company, this one promoter, you will not be able to track only. So literally, if you need to take a pen and paper, draw a diagram to understand, or draw, if you're good with PPT, draw, but make a structure. Like, you can, I'm showing you on a page like this, you can draw squares, you can draw a diagram, and so that you have one photographic representation of the structure of the transaction. Draw a photographic representation with pen and paper. Best thing. Why I discourage using only soft copies is because you will get damn confused. Okay, because like, it's first thing you have to do is focus on how to draw in a PPT, versus on your pen and paper you will just draw and then you'll tear it away if the drawing is wrong, and then again you will draw. So that will be very easy, and if a senior sees you work like that, they are going to be really impressed with your with the way you think and with the way you keep things clear. Who gains and how? So commercials and who gains and how is very, both are interrelated. Commercials may be purely this, that I get so much work money for so much of the service that is provided, but I may have more details to it, like, my service should meet this quality, I must provide it at this level. Okay, so there may be more details to the commercials which I must keep in mind. Like, for example, if an investor invests in the company $10 million, the company gets $10 million. What is investor getting? Okay, some equity in the company or some stake in the company, but how will they stand to gain more money in the future? Okay, how will they ensure that their risk is going to be minimized? So a little more details are important to understand. Okay, one very important thing I must tell you is that working from a suboptimal mental state, people don't talk of this as a drafting issue, but thinking of the right mental state, being in the right mental state is very important to be able to think of drafting. Okay, anxiety is always there when you see a big contract. There's anxiety of deadline, anxiety of not knowing the subject matter, anxiety of impressing your senior. All of that is there. Overwhelm is there is too much to look at, too much information to sift. So one classic reason you face overwhelm is because there is too much to do, and you don't have, every information is new. So if you are more trained, you know more, you learn better, you're more prepared, then the amount of new information that you will have when you're doing work will be less, so you can process it faster. Okay, so overwhelm is not from a state of, Array, don't be overwhelmed, there's, you'll figure it out. I'm not saying from that perspective. I'm just saying from this, that you have too many new things when you get your first assignment, versus having 20% new things when you get your first assignment and having a head start. Okay, how will the two influence you? If you have everything is new, you're going to be overwhelmed because you will not know what to do, you will be confused and clueless. If you know a few things, then what happens is that you get a jump start, and you will feel, your brain will say, oh, very good, I know a few things. And the few things that you don't know, you will be wanting to solve that. Okay, uh Weber, what are you asking? No, this is not by for representing a client. Just being given the work to do, whether it's drafting work, even if it's an intern's work. Okay, you will have the anxiety that I've got to do it right, I've got to do it fast, and they'll be overwhelmed that how do I do this? And then the whole question, because there's too much new stuff to work with, and the whole question that how do I impress my client or my senior? All of this. Okay. Sukriti, you asked a question. Um, I remember my dad's bank asked him to make a power of attorney and you didn't know what to say to help. I just told him to go to a banking lawyer. Brilliant, Sukriti. Very, very good information. This will happen all your life till you learn how to draft contracts. This is basically opportunity knocking at your door and you saying no to it. Okay. So the first thing we do when we teach our students is that say yes to all help. You can obviously say I'm not an LLB, but people are coming to you for help even as a law student. Your relatives will come to you, your friends will come to you, other students will come to you. So you want to always say yes to help and have a resource so that you can do the job. Okay, because that gives you the sense of doing something professionally. Because see, what happens is if you do 80% of, if you study for your exams, and you leave a few chapters out of the syllabus, then what will happen? You will get 80%, 60%, 70, 50%. Nothing much. Okay, you will feel bad about it, but when there's client's life on the line, or your reputation on the line, You will not be okay even with a 90. Like one thing wrong, you'll be like, no, I need to double check, triple check to ensure that I do 100% properly work. Right? That is what is important. Okay. Um, Anubhav, commercials and who gains and how, for now, it's fine if you collapse it. Okay. I've just written it. There's a bit of duplicity in it. Okay. What laws, Prasanna, should you get acquainted with? I think, Prasanna, the law part I'll come to later, but I would say start getting used to clauses. Start getting used to writing a clause end to end from scratch. Start reducing your dependency on templates and start reading more contracts. Okay. Start from there. Do not go into statute. Okay. We are too statutorily winded in our head. Okay, so what will happen is people will think that, oh, I should know the statute, but actually you need to know the commercials. There are US lawyers who draft Indian contracts. Sometimes they go way very wrong because they don't look at the statute. But the first thing right now, as a first year student, your LLB syllabus will teach you a few statutes. What you will not learn is the drafting, reading, and the writing and the reviewing. Okay, so that's what you want to learn, Prasanna. Your Indian Contract Act subject will teach you some parts of the statutes. You don't want to look at statutes more than that unless you need to. Okay, and where you need to will be very easy. Like for example, you're buying a house from a builder, which who is building a multi-story. The RERA Act defines, what is the sale deed format, but that's about it. Okay, beyond once you buy the house and then you have to sell it to somebody else, again it will be non-RERA format. If the builder has less than 8 flats, again non-RERA, only transfer of property act, some aspects of registration and how the transfer clause is worded. After that, you have to again go back to your general commercials, which can change based on the nature of the property, nature of the contract. Okay, web of clauses should be as direct, simple, and straight as possible. Okay, so should I move to the next part? Should I move to point 3? Say yes and say no if you want me to go back. Okay, web of question answered. Prasanna, any sources to name? Sources to name for what? Prasanna, stay here. No, we have a lot of time. Tomorrow also there's a 3-hour session. You register for it. We'll discuss how you can learn and what you can focus on. Right now, what are we focusing on? We're focusing on the mistakes, pitfalls to avoid. Okay, so let's go. Waiting for instructions before taking initiative. It's like this. We have to, once the client gives you a matter or a senior gives you a matter, it should germinate in your head like a seed. That is like, where a sapling will grow. So you have to sit, think about it, think about the potential problems that can arise. There are 2 parts to every briefing that you get from a client or a senior. I'm assuming 2 or 3 standard scenarios: client, independent client, or a relative who has come to you, or a friend, or a parent or your parents have asked you to help out with something, okay, related to their business. All of that is one. Basically, it's a client. Okay, whether they are paying you or not is immaterial. They are a client. Another way is a senior has asked you that help me out with this in an internship, okay, in a law firm or with a litigator who got contract drafting work. Here, there is one briefing that ye karna hai. This is what you got to do. And the second thing is you want to think that what the deal is and where you can add more value, where they didn't ask you to do it. Okay, the 2 are separate things. You want to think on both planes. Okay, why? Because second plane is going to help in impressing them, but it takes time to think of value additions. It's not going to be super quick. So you take your time to do that, but don't mix it up. Okay, don't add random value where it's not required. So before adding that value, you call people and say, hi, you asked me for a power of attorney, but what I see here is that ABCD also is needed and you need 3 power of attorneys here. If you have other offices, you may need more for those. You may need to draft it like this. All of that you can discuss. Okay, that's a value add. So before you do the job, you talk to them. Do you need this value add? I think this will help. Okay, so you have to take initiative directly. When you are drafting the contract, most people have a very simple conversation. Client says, I want a contract. Lawyer says, I'll charge you this much. Client will say, give me a template, or why so much, negotiate it down. Lawyer will negotiate it down in the worry of not losing the client. And then you do a mandate for dirt cheap. Later on, client realizes there's a problem. Then you have a problem that you were underpaid. So why should you work so much? All of that keeps happening. So that's a never ending circle. Could you follow the never ending circle right now? Tomorrow, 6 to 9, Aruna, I'll take you through the registration link. It's free at the end of this. So if that that process of taking review from the client is not going to work, so you want to actively lead the client into, okay, so this is the commercials of the deal. How are you going to make money? What is going to happen if they do this? What is your proof of delivery going to be? What quality do you need? How do you measure it? What are the objective standards to keep? what are the things that could go wrong. You will think through them also. You will ask the client also to think through them a little, so that they can identify some of the problems that'll hit them. Okay. And all this conversation will happen before drafting the contract, so that at least you have some customized framework to provide the client. No matter how many templates exist in the world, you will find yourself doing a fresh contract every time. You may not draft a whole contract from scratch, but every part of the contract that adds value, that you're getting paid for, or that you're getting acknowledgement for, is going to be things you added on your own and no other way. Then this is a very common one: not checking defined terms properly. If you don't understand the contract, what will happen is, in the big contracts, you have 10 pages of definitions, 5 pages of definitions. It's huge. And then not checking the rest of the, pages. Like if it's a 80-page contract, the remaining 70 pages, you'll not check, are there any other capitalized terms? Do I need to define them? Sometimes the terms are not defined in the definitions clause, but you'll just say transferred property has the meaning assigned to it in clause 4 of this agreement, for example. So that process, you have to be very, very strict and rigorous. You can't afford to make a single mistake, because it impacts the professionalism. Okay, so you should check all the defined terms. You should check that every time they're used in the document, they are capitalized. Why? Because if they're capitalized, they have the meaning that you have given. The defined terms are basically, literally, it's like writing a novel. Okay, you are creating a fictitious definition of a term to mean a particular thing, so that people stop referring to the General Clauses Act, people stop referring to English dictionary, people stop referring to Black's Law Dictionary where you've defined a term, people stop referring to case law where you've defined a term, because you've given a specific technical meaning to the term. Okay. So, Aruna, there are various levels of contract drafting. You start always at the first level, start drafting on your own. Don't start with using templates. Very senior in-house counsels also say that the problem they face is they've been working so much through templates that they feel handicapped when they have to draft their own contract on their own, or a new type of deal. Okay. Murthy, feeling difficulty. Is it fine, guys, if I keep addressing the questions? Sometimes I feel that they're very relevant and keeps people engaged also. Say yes if it's fine, okay? Okay. So say yes if it's fine, say no if it's not. Because why? Because if somebody's asking question, it should contribute to you also. I'm trying to keep the answers relevant for everybody. Okay, great. So Murthy is saying sequence is a problem. Murthy, sequence is not at issue in contracts. Okay. Yeah, people don't like a random sequence, but otherwise, sequence is not going to affect the legal implications of things. Okay. Usually your sequence will be like this: the first, after your title, parties, date, all of that, you will start off with your definitions clauses. Then you'll go into something called the operative clauses. Okay. Or mechanic, where you will write the substantive obligations of the parties, the standards at which they should deliver, what is acceptable, what is not. Okay. And then you will go into certain clauses called boilerplate clauses, but they are not boilerplate because there's customization. But these are around, like, there's confidentiality, indemnity, representation warranties. And then you'll go into dispute resolution clauses. Then you'll go into further more boilerplate like severability, entire agreement clause, and all of that. Okay. But we'll come to that. Okay. Yeah, recitals and all will be there. So I'm just telling you really fast everything. So I'm giving you a flavor, okay, at what sequence you put in. Recitals can't come at the end. Obviously, recitals have a very specific place. It moves right before the first clause. Okay. Harsh, okay, I'm just taking a few more questions. Web can a slightly different or limited or expanded meaning is given to a term? You can do that through your drafting. That's not a problem at all, Web. You can change the meanings given to terms. Harsh, how many times does one use pre-existing templates? Always you take 2 or 3 pre-existing templates to refer to, understand, and then you may start off blank, or you may take some terms from a particular template. But remember this, always some firms come up with something called a standard form precedent. Okay. In trilegal, like they were working on a big initiative to make standardized precedents. Okay, which was a super exhaustive way to draft any agreement of that nature. But a lot of times you will look at prior deals that you did, which were most closely matching. But in different places, you will find different kinds of prior deals. Like you may not find something that's exactly matching in a particular firm. And in some cases, you may find something that exactly matches. Okay, so basically your ability to work with an imperfect template identify the problems and fix it is what is important. Okay, because your quality of output cannot be subject to the quality of the template that you have access to, because that will not inspire confidence for a client. Okay, on a scale of 1 to 10, yeah, so you got it, Harsh. Then not checking so this is done. Let's look at the fifth point. Not having a sense of mechanics and sequence. This is not sequence of the clauses, not clause 1 to 10. No. Sequence meaning imagine the transaction flowing beginning to end. Okay. For example, uh, you have a shareholder. I'm taking example of shareholders agreement. You can take any other also. You can take even buy and sell agreement also, like any property sale. But let's take shareholders agreement. So suppose share subscription agreement. Okay, investor is investing into the company. So one clause will say that this person will invest so much money and get so many shares issued to him or her. Okay, that's for the investor. Okay, now that's fine. That's the substance of the contract. Now, when will that happen? That'll happen on a certain date. Okay, what needs to be done before that date? Okay, A, B, C, D, E, F, G, these are conditions precedent. Once these are done, then what's the confirmation that's going to go? This A, that's called like CP satisfaction. It's called a conditions precedent being satisfied. So how do you determine that? You say that the last of all the conditions are going to be satisfied. That's when this is going to happen. Then parties will meet on a particular date, do these 5 6 actions. There'll be wire transfer of the money into the bank accounts of the company. There would be issuance of shares, approval of all the resolutions at the board level, at the shareholders level, approval of the amended drafts of articles of association, which are to be filed, okay, with the ROC. I'm giving you an example. Are you able to follow this with me? With me, everybody? So this mechanics, if you don't do, your contract is going to be all haywire and all over the place. Okay, because then you will not leave the right space for due diligence. Your representations, warranties will go here and there. Like, as of when are they true? That will not be clear. Okay, so those problems will arise. So your mechanics, sequence, and timelines are very important. This is there in every contract. Everything that has to be done has a logistics or an operational angle to it that needs to be appropriately worded in the contract. You will not write every little thing, but you will write the broader aspect that must get completed, like all necessary approvals must be obtained. That is one way to say. Okay, then another place you will find mechanics and sequences. When you have like a right of first offer or a right of first refusal clause, you will have a notice being given by the selling shareholder to the other people to give a quote, failing which they can go and sell to outsiders. That kind of a thing is there. If that doesn't happen, then they can do something else. Okay, so that whole sequence you should be able to map out. Okay, it's almost like ABCD. If this, then this. If this, if not this, then this. Okay, that proper branch should be there. You can do it diagrammatically for your own understanding. Okay, now what this approach will help you irrespective of whether you don't know things before, and you will be able to map out when you see a new agreement. Okay, not knowing which party or firm is acting for, this is especially important if you are uh, if you are making your first contract, also if you're reviewing, because what if you are reviewing the contract in a way, even as an intern, that is strengthening the other party's position. When you are reviewing a contract, you will always you will spot things that should be done in the other party's interest, but some things you will leave because you don't want to overprotect the other side. You want to create a balanced contract. Some parties come with the approach that our first draft will be completely one sided, favoring us, and after that we'll start the negotiation. Okay, and sometimes the mandate is that create a balanced draft. Okay, either of those cases you are not going to go out of your way to protect the other side, right? So that's how you have to review your use your contract drafting and review skills. It's like a sword. You will use the sword for a particular purpose and not for other purposes, even though you could, but you will not use it for those purposes. So you can't use it for self harm, right? That is what it is. Okay. Subhashans, most of us invariably see and search for specimens from Google, and stored standard clauses can be taken from. Sure, you can, and then you will, but how will you decide which standard clause to take, which one not to take, how to amend every standard clause? You can see the heading of the clause, then you can read it. Then when you write it, then you will have to again completely edited in a lot of cases. Check on Google, you will always find that you want to edit it. I have not had even a single instance where I could use a pre-existing template, despite having access to hundreds of templates. Our contract drafting course has more than 100 template of every contract. Our various courses have 700, 800 templates. Doesn't matter. Every time you draft a real contract, it's going to be like a nice, what do you call that, platter. You will take different clauses from, you will add 20 new clauses of your own. It will always be like that. Okay, sometimes you'll take regard to clients and sensibilities and simplify the contract. Sometimes you'll go in a lot of detail. All that will be there. Okay, so where were we? So not knowing what party your firm is acting for. Once I had somebody, a student, take inputs on how to review a software development or a software license agreement for a potential client, and she gave it to a relative, and the relative the relative was working in a big law firm, and the relative actually reviewed it from the other side's perspective because the relative didn't have enough experience. So what you have to do as a young lawyer is know your which is the client and how do you protect that client's interest. That happens only with prior preparation. Okay, are you all with me? Seventh, not checking whether the agreement is sufficiently stamped and registered or not. So this happens at two stages. One is at the contract execution, meaning signing stage. At the signing stage, a lot of contracts are fully executory in nature. If you studied contract act, you know where my obligations trigger in the future and they are subject to certain fulfillment of certain conditions. They may be fully executory in nature. Okay, now irrespective of that, what will happen is that at the time of execution, I have to check for enforceability, is it stamped or not? If there's a dispute, I know that this contract is going to be going in evidence. So at that time, I need to check that is there a stamping issue. A lot of times parties just do not register a contract where it's necessary to, or do not stamp the contract appropriately. They may use the wrong state stamp paper, they may use the wrong calculation, it may be understamped. All of that can happen. There may not have been a registration where it is needed and parties may have just notarized it. These things happen. Not identifying internal conflict or contradiction within the document or across connected documents. So there are two types of conflicts. Okay, you may use the same term in different contexts. You may have conflicting clauses saying if X happens, Y will happen. If and then something else saying that something else is going to happen. Okay, so you can have internal conflict within the same clause within different parts of the document, or two different documents will be internally inconsistent. For example, if the bank is to take possession of security, then that will be written in your loan document that upon an event of default this can happen. Now that one that the if there is an event of default, the bank will say it's an event of default, and if it's not rectified within 7 days, the bank can use its statutory rights to enforce security. And in your security document something else may be written, okay, which is not connected to your loan agreement. Then there is a problem. Okay, so this is also a problem a lot of times in dispute resolution clauses. When you have 6 documents and you have one parent document that governs the entire deal, you will need one disputes resolution clause in the master document, and in all other documents you will cross refer, you will have a cross referencing to this main disputes resolution document and say that this is the disputes resolution clause which applies to all disputes within the scope of this agreement and all the other agreements covered here. You will also have a very clear identification that these are called, one expression is called this agreement, which is the current agreement, whichever agreement you are currently looking at. Okay, then you will call one set of documents as, let's say, the transaction documents. In a transaction, you can have financing documents, you can have security documents, which are called separately. So you can cluster groups of documents together and then you can refer to them in one word. This makes your drafting much easier and simpler. Okay, non-identification. So somebody is asking me what to do about statute. That's here, non-identification of statutory provisions that are applicable and how they tie into the terms of the contract. Like if you have an insurance contract, okay, IRDA has a 30 days look through period. In 30 days I can cancel the contract after getting an insurance policy, paying the premium, and then if I cancel the policy, I will get the money back. Okay, that is an IRDA thing. Then you can have RERA, real estate purchase agreements under which are governed by RERA, which are when the builder first sells to the flat buyer. Okay, there will be a template. Then there can be templates. So various statutes will have templates. Try Telecom Regulatory Authority of India. When it issues licenses for telecom, it will have, for telecom service providers, that will have a standard template. Okay, so there are certain scenarios where you have a standard agreement. Either the terms are written very clearly that these matters the agreement must govern, or the format is also specified. Okay, so there you will have to look at those formats. Sometimes you will have some freedom to add new terms. A specific version of an employment contract is a standing order, which you use for employing workmen in a factory or in an industrial undertaking. That is a pre-approved employment contract. It must contain all the heads that are specified in the law. It may have the clauses also worded exactly the same, or there may be a deviation, but it must be approved by the authorities. Okay, so standing orders follow a particular format. So now, depending on which space you're working in, there will be specific formats for different contracts, but 90% of the contracts are not regulated. Okay, but I'll tell you one thing, like if you're looking at a construction contract, there are organizations. FIDIC is one, ICE is another. They have specific models along with you will make the contract. These contracts are internationally following the same pattern with some Indian customizations. Okay, not a lot. So that format will work. A syndicate loan agreement may be based on a format such as an Asia Pacific Loan Market Association format. Okay, so all these become these, there you have standardizations. Supravo penalty clauses, if you've studied contract law, you know that they are not valid, and one has to show damages. The way a construction contract causes words a delay penalty, that's different. Okay, it has to be adjudicated on whether there is a realistic pre-estimation of loss in that penalty clause. Okay, in any case, labeling the EPC, the clause, as a penalty clause in an EPC contract is can be dangerous. Okay, unless you've checked that this has been upheld, and you have to say that this penalty is like commercially being called a penalty. It's not in the nature of a penalty clause. All right. So not looking at whether there is sufficient expression of the commercial intent. I've found a lot of contracts which I reviewed, and after I reviewed, I'm like, hello, this is what this party wants, and where is that written? Some parts of the commercial intent are written and not a lot. Like someone wants to draft a co-founders agreement, they will say these people will be the co-founders of the company, and they will say this is the equity they will get. They will do all the work as of the company that is needed, and they'll stop at that. But you need full expression. What are the risks? What are the dangers? What are the requirements? What are the obligations? Okay, all of that. What is their minimum commitment going to be? Are they going to do something competing or not? Are they going to commit full time? Can they do side ventures so that they can earn side gigs, or can they do a job on the side to earn their survival money? That happens in a co-founders agreement, right? So can they do all of that or not? By the way, one more thing I want to highlight in point 9. Articles of association of a company have a pre-specified format when you first incorporate a company. So there again, Companies Act, there's a table in the Companies Act which applies. LLP agreements have a format which can be used. So LLP agreements don't have the exact wording; they have a default set of rules, and it also says that which are the heads which you must address in an LLP agreement, and everything else is bonus. Okay, so depending on the contract, you have to first see whether a particular statute applies to it or not, and then you have to see whether they have prescribed either only criteria or they have prescribed the whole format, which you have to take and then customize it. Okay, Prasanna, I hope this is helping you out. Yes, Harsh, thank you for adding value. Table F is there, and there are different tables for companies. Table F is the most popular one if the company has issued shares. Sometimes there are shares, companies with a guarantee and all of that. There you have different tables. Okay. Murthy, very good. You're writing more complex sentences and not being able to write precise and simple sentences. Very good. Okay, good that you're identifying these gaps so that you can work on these. Not looking for a limitation of liability clause, not while reviewing, and while drafting, not drafting one. This is very important because, so one way to see is that every time you're entering into a deal, your risk should be capped. Okay, whatever happens, anything, whether your primary damage or indirect loss, whatever it is, it must always be capped at a particular ceiling, and nothing Nothing more than that. Why? Because otherwise you will end up taking the risk of various kinds of losses that can be caused to the other side. Irrespective of what default contract case law says, if you cap your liability, in a lot of cases it will be upheld. In some cases it may not be upheld by courts. Okay. Where it will not be upheld by courts is where there is a supervening consumer interest and all of that. There it will not be upheld, where it is going against law. But in a business to business contract, which is where you'll be most of the times drafting for parties, if you're drafting terms of use, privacy policies and all, there you are looking at end user, like customer facing clauses. There also people have, in all software contracts, they have a limitation of liability clause. Okay. So you have to always keep this clause in mind in any contract. Do I need to limit my liability or not? Okay. So what do people limit their liability to? Free software may, they will say that your software is being purchased on an as is basis and there's not going to be any liability. If you purchase software and you pay a one-time fee, they will say liability limited to the fee for it. If you're taking service like software as a service and you're paying a monthly fee, they will say this is limited to the fees paid in 6 months or in 3 months or in 1 year. Okay. So Sukriti, liability limitation is, suppose I'm taking, Dropbox say I'm taking a paid account of 6,000 rupees a month. Okay. Now Dropbox will say that whatever happens, your liability, our liability to any loss caused to you for any loss caused to you will not exceed the subscription fee that you pay us for 1 year. Okay. Why that is helpful to Dropbox? Because otherwise I will say that I stored my passport, some details of my bank account on Dropbox, and that got hacked and Dropbox was negligent and 1 crore got wiped off from my bank account. Now I'll say Dropbox was negligent, because of which I got a 1 crore loss. There was a security breach on your machines and we've identified this was because of your negligence, and because of that somebody got access to my account and they have taken out 1 crore rupees from my bank account. The password was written in a file that was there on Dropbox. Understood, Sukriti? Everybody understood limitation of liability. So Dropbox will say whatever happens, I am not going to pay you more than what you paid me for 1 year. Okay. Yes, no. If you understood, say yes. If you didn't understand, say no. Okay, so you must have a limitation of liability clause. The second thing is you must also look at so a blind limitation of liability. Good. Blind meaning in all cases, whatever happens, I'm only going to be responsible for 1 year of fees. But you always want to be responsible even for that. Like there could be random things, ripple effects, indirect damages that could happen to people, right? One thing happened and after that there is another consequential ripple effect that has happened. So the loss starts to get amplified with every step. Okay. So you need to look at the substantive aspect of damages. Always, if you look at any liability clause, you will see only direct and foreseeable damages are always specified. No consequential damages, no indirect damages, and no special damages. Okay, these words are used. There are contract theorists saying that some of these are superficial words, they are repetitive words, but all these three terms are important. They mean slightly different things. I'll give you an example. Okay, consequential means what? Step one, this damage not addressed. Step two, damage is aggravated, right? Like you have an infection, you have a snake bite, for example. You will need to address that. Okay, you'll have to fix that with a medicine. But in some cases there's a secondary bacterial infection which you get if you in case of certain snake bites. Now, that's the second level of infection. That's not the snake bite problem. That's not the venom in the snake's bite, but that is, or the injury from the bite itself, but a bacterial infection over it. Over and above that, there can be a new complication, right? So that becomes consequential, one after another after another. Indirect is what? Indirect could be anything. There was snake bite on the road, and you fell in, and you something happened. There was a moving vehicle, or you hit your head on a stone. Okay, that's a indirect, not foreseeable. That's not consequential. That is more indirect than consequential. Okay. Special damage is that you were a particularly weak person, so a snake bite, which is non venomous, shouldn't have caused something really wrong with you, but you actually suffered a fracture. Okay. So these three are variations, but in every situation, you will not be able to identify all these variations or predict them in advance. So, as a general rule, parties write all these three together. Okay. It goes like some kind of holy trinity. Followed, guys? Everybody? So you will find it now today, now tomorrow onwards. You Google, do whatever, find any template, look for this term: consequential, indirect, special damage by Control F, and then you see this in 2-3 clauses how this has been defined. Look at how your limitation of liability is defined. Definitely, anytime you install software on your computer, okay, any app you install from the App Store, in they will have end user license agreements. They'll have a limitation of liability clause. Okay, so you look at it, see what will happen. When you're drafting or when you're reviewing, even as an intern, you must explore what if scenarios. Okay, this is a standard in the books. What if this happens? What if that happens? But the thing is that here in a what if scenario, what are you doing? You're playing devil's advocate. Which app? Meaning App Store, Apple App Store, Android App Store. Download a software like .exe file, .msi file. You know all those softwares you download, right, directly from the website or the App Store of the company. So in Apple, it is .dmg file. So when you install those, any software sitting on your computer, they will give you an end user license agreement, or a EULA, it's called in colloquial. EULA is spelled as EULA, pronounced as EULA. Okay. Okay. So not exploring enough what if scenarios. This is about what can go wrong. What can go wrong in a franchisee deal is going to be very different from what can go wrong in a rent agreement. Is going to be very different from what can go wrong in a software as a services deal, and that's very different from what can go wrong in a loan agreement. That's very different from what can go wrong in a celebrity endorsement contract. By the way, these sports endorsement contracts are pretty interesting. Even movie actor contracts are pretty interesting. We were talking about jargon, right? So there, some of the jargon and what if scenarios that are there are around. Suppose an actor needs to be paid fees, so the actor's incentive will be based on the gross sales of the company at the box office. And in a scenario such as Corona, where you're releasing a movie for digital release, your revenues are going to dip. So what's the actor going to do? Because your revenues dip, you can't measure box office sales, you can't get incentive. So you may want to prevent that without actors' consent and without giving a further compensatory fee to for the digital release. This problem happened in case of release of the second Wonder Woman movie. Okay. uh Celebrity in sports endorsement deals, it's like, we'll pay you this much for if you are performing at the top in the world rankings. If you're a tennis player, if you're a cricket player, you must have scored at least this much, you must have got man of the match in these many last matches, or your batting average should be this much. uh you should have been ranked on the tables at this, or India should have won this, then this happens. Okay, so everything, basically all your commercials get linked to your sportsmanship performance. Okay, which is why if there is a scandal that happens in sport, it affects players' professional lives and personal lives in a big way. Okay. uh, yeah, so Anubhav, it goes beyond just defining terms. It's like what can go wrong in any direction, which is why knowing the commercial ground of the deal, the scenario in which you're sitting in, that's going to be very important. Familiarity with that. So I just gave an example. Did you all follow the sports endorsement deal? Like, what happens? Let's say if Dhoni is doing an endorsement deal. Okay, what happens if he's no longer captain of the team? Okay, that's going to be really important. What happens if he's got 3 ducks in a row and his ad comes after he just got out? Okay, so the advertiser is going to think that, and they're going to say, no, then we are going to pay you a lesser fee. Okay, not looking for so this is mischief, complete mischief protection. Not looking for anti-circumvention clauses, reverse engineering, or anti-cloning provisions. You want house from a broker, through a broker will say, you will not circumvent me and directly establish contact with the client. Okay, slightly different from non-solicit. Reverse engineering, you download and install the software. Okay, and then you will not try to reverse engineer the same software by breaking its code down, which you install. Okay. Then anti-cloning provision. So anti-cloning was something that I saw specifically in a cross-license agreement between Microsoft and Apple. This is there in cross-licensing agreements. Okay, what happened in 97 was that both Microsoft and Apple cross-licensed some parts of IP, some patents and other IP to each other. And they said that from this date to this date, whatever our patents were, the use of that is being licensed to you for a 20-year period. Okay, but they said anti-cloning. What is anti-cloning? you will not on your own make that product, or sorry, you will not make on your own that technology, because then we will assume that you have taken it from our licensing deal and you've got access to certain information. So you will not clone this by yourself, and then so that you cannot claim that I independently made something, because it's really likely that you would have made it from getting access to our licensing deal. Okay. Expected fees for drafting a contract can range from, like, you could charge 5,000 for a simple NDA, even 2,000 to 50, 60,000, 1 lakh. Big law firms charge 5, 6 lakhs also, 10 lakhs also for big deals, if more than that as well. Okay. As an independent practitioner, you would charge anywhere between 10,000 to 80,000 for complicated contracts. Okay. In a 60,000 or 80,000, if you're charging, you will do 2-3 more contracts together for a deal. Okay. For the whole deal, you will charge that. Okay. Not focusing on the sequence of dispute resolution is also a big challenge. What does that mean? This means that how does a dispute get triggered? If there's a breach, do I immediately go to courts? A lot of times people go to court prematurely, or they initiate arbitration prematurely, as a result of which their steps, their dispute resolution strategy gets delayed. If you go prematurely, the court or the tribunal will say, first do this. You may go to the court for appointment of arbitrator, even in arbitration, and the court will review. An institution may not review it in so much detail if you have institutional arbitration, but if you have a court named there, then they will say, you've not exhausted this clause in your contract. First you do that, then you come for us to arbitrate. A lot of this can happen. Okay. So you have to focus on sequence, that uh, if there's a breach, then what needs to happen? Okay, 30 days cure notice needs to be given. Great. Then what needs to be happen? Oh, parties need to talk to each other for 30 days. That's 60 days gap period before going to court, which means that one defaulting party can take somebody for a ride for 60 days before you have the right to go to court. Okay, those problems can happen. So you want to see what the sequence is, and you may want to shorten it. You may say, I'll give you a notice of breach for 7 days. After that, I'll try to talk to you another 7 days, and it doesn't happen, I'm going to initiate arbitration. Okay, you can compress the 60-day period into 15-day period, where it is important for parties that cash keeps coming in, things are proper. Then this is very important. In other contracts, like, for example, like, you may have a very one-sided view of a contract, like a sale contract, an investment contract. Sometimes you just say that acha party will back out, but in many contracts like construction arbitration claims, you will continue to perform. Okay, and you will just keep a document trail and start the arbitration. So two parties will be in a working relationship, and they will file claims, so that any adjustments to the consideration that they must get are provided for commercial. So relationship is going on, work is going on, agreed payments are going on, but on the disputed parts, the arbitration is going to continue. Okay, so there you have to know this, that how the claims are to be identified and how it's to be done. Then not limiting the jurisdiction to courts of a specific jurisdiction is a big problem. You must use the word exclusive. Even if you're using arbitration as the method, you will still need to say, okay, this court will have, it's better to say that these courts of this area would have exclusive jurisdiction on the matter. In case of arbitration, not drafting the arbitration clause tightly enough is a big problem. Having a loose arbitration clause, just saying that disputes will be resolved by arbitration, is a big problem. Not identifying arbitrators, qualifications, or appointment process is a problem. Now you've got the fourth schedule, at least you can say that, the fees of the arbitrator will be as per the fourth schedule, fourth or fifth, I'm not sure. Yeah. So as per the schedule in the Arbitration Act. And a lot of times now, but the judges may not want to stick to it. If a retired judge is going to be hearing your arbitration, they are not going to, they may not stick to that. So that's a problem. Okay. So here, these things have to be thought through. People don't think through a dispute when they are thinking through drafting, but that's not okay. Because when the dispute happens, your drafting may come up with many holes, and parties may decide to, the party may lose trust for you. And if you have a very tight dispute clause and your contract stands the test of time, the party will be very proud of you, and your client will always want to approach you. Okay. And even a domestic arbitration clause requires a lot of these logistical details to be there. Both international commercial arbitration, also domestic arbitration clauses also. By the way, there's a term, anytime you do a detailed study on international commercial arbitration, we also teach this in our course. on international commercial arbitration, there's a term called pathological clauses. All the stuff, all the jurisprudence on seat versus venue debate, all of that you've been hearing about going on for decades, literally, is because of pathological arbitration clauses, because the clause doesn't have a few basics set in its aspect. Okay, and this term was coined in 1974 by an arbitration researcher, by a jurist, but this has continued for 50 years. Basically, that gap hasn't been bridged. So you have new jurisprudence everywhere on the pathology, on pathological clauses. Not looking precisely at what constitutes a breach, a material breach, or an event of default, very important. People do not look at, when you'll say any breach will trigger this. What is a breach? Which are the obligations you want to trigger X? What are the obligations you want to trigger something else? Sometimes people use the term material breach. Material breach you never want to use if you don't qualify at least certain situations which would qualify for that. Otherwise, it will always be a dispute about whether there has been a material breach or not. Okay, event of default, for example, again has to have a very specific meaning. You can define it differently for different contracts. Okay, but you have to name examples of situations, like 99% of the situations that you can predict, you must list there. And there are going to be 5 or 10 most common situations that will lead to a breach, where you will pull out of the deal. Okay, or where you will want, like, proper, you will sue for damages. You want those to be defined, because the question of breach should not be disputable. Okay, non-identification of proper standards of responsibility. Sometimes you need to say qualitatively, like, you will take your best efforts to do this, you will respond promptly on this. Okay, or, and sometimes you need to have specific timeline, like a service level contract or a cloud computing contract will say there will be 99.99% availability and uptime. Okay, that is a quantitative requirement. So where to put a qualitative requirement and where to put a quantitative requirement has to be very important. So cloud computing agreements, service level agreements will have quantitative aspects. Anytime you have a schedule, a statement of work will have a lot of quantitative aspects. Qualitative aspects will be more like in the nature of duties, duty to comply with all the applicable law at all possible all times after receiving the investment. Okay, duty to promptly notify the other party of a material adverse effect in its position. Okay, that kind of thing is qualitative. But you want to have both the right qualitative aspects, because everything cannot be quantified all the time. So you want to have the right qualitative aspects also, and you want to have the right quantitative aspects also. Okay, not scrutinizing information in the schedules. So every time there's technical detail in an agreement, it goes in the schedule. You want to scrutinize that carefully. Sometimes names of parties are in the schedule, where you have 20 lenders in a document, then they just say lenders on the title page, and then they put all of them in the schedule. Okay, so you want to see who the lenders are always. Okay, and now there are some basic bonus points to consider. Check formatting, updation of page numbers in the table of content. Always look for line spacing gaps. In Microsoft Word, there's a dirty additional paragraph spacing that keeps coming in from time to time. You want to remove any additional extra spacing or indents. You must have a convenient amendment framework. For example, if you're acting for a lessee, you may want to have a automatic, or a licensee, you will want to have a automatic renewal process. If a licensor is there, they want to renegotiate terms every year, they'll say, I want to negotiate always. So they must always, at the time of expiry, there must be a renegotiation of the terms, and then that will be added in a schedule so that I can get more license fee. Licensee will say no, automatic renewal and the same terms every year. Okay, so that is how both parties will want to act differently on this. Okay, using complex drafting standards and language that are out of sync with the client's requirements is also a big problem. What does this mean? Some clients want technical, like detailed clauses, like you're doing an M&A deal, very detailed clauses. Professional franchising deal, detailed clauses. You're doing a rent agreement, try to do a good detailed one with a regular homeowner, even if it's for a company guest house. You'll realize that they get scared of the contracts that are long. And you can't tell them intellectually that, hello, this situation won't materialize, no problem. But I'm writing it if it materializes. No, they'll be like, no, this is too much complex stuff. I am scared of this contract. I don't want to use so much. Okay, so you have to use the standard that is appropriate to the parties. If you want to learn more about drafting your first commercial contract, join me tomorrow in a free session. Asta is going to share the link with you on the chat right now. I would invite you all to go to the link and register. It's free, 3 hours, volume of free training, all the best insights that I've got while training people to draft contracts. Okay, will be here. I can assure you that after the session, you would be completely delighted, and you'd be sure that you've not got the value elsewhere. Okay, here you can see what is it that we are going to cover. We're going to cover uh, when should you start learning it, what you need to do to draft a effective contract, mistakes to avoid, can you really perform contract drafting work as a fresher or as a law student, what are the best ways to find loopholes in a contract, how to demonstrate to a client that I have done this work, like that I'm going to add value, because clients will always negotiate your pricing down. They'll say, why so much time, why so much money, can't you just give me a template, how is your drafting different from what I get on a standardized website like Rocket Lawyer or something else. How is it different from another lawyer who's quoting me half the rate that you're quoting? Okay, then can you perform contract drafting work in a small town? How can you get that? Okay, which are the tools to use to learn contract drafting? Can you charge money for it? How are principles to use to actually charge clients? How do you get repeat work from the same client and new work from new clients? Okay, will this help? How will this help you if you're working in a law firm or if you want to be a litigator? All of this will be covered. Okay, this is the workshop link that has been shared with you. What you have to do is go to the link, write your name here, let me know once you register. And some of you may have already attended my webinar earlier and registered. Great, see you tomorrow. Thank you for being there and for registering. Those of you who haven't registered still, please go on to this link and let me know once you register. Okay, I'm really excited. It's a funny flattery, thank you. Okay, but you can be like 200% better than anybody else, and you can be yourself and do an awesome job at that. Okay, all right, and you're doing fabulous, Harsh, by the way, from your comments and the value that you're adding through participating in the webinars. Okay, Prasanna, so come to the session. Anubhav has shared some interesting takeaways. Very good, Anubhav. Mukesh, great. Prasanna, did you register? Okay, great. Happy to see you all register. Tomorrow at 6 p.m., let's have an awesome time learning contract drafting. I promise to make it unique and unconventional so you will be engaged and enjoy the session. Okay, so cheers, everybody. Any other questions you all have? Would you all like to share some takeaways? What can you implement from today's session? Which mistakes, do you resonate with the most? Which ones do you think you can use? Tomorrow you will understand even if you're a second year student, Sudarshan. Yeah. So what are your takeaways? Anubhav has shared some 10, 12 takeaways or more. What about the others? So try to think of one takeaway. How it helps you is that you can think, your brain will learn and know the takeaway much better if you try to write it, because the articulation cements your learning. If you don't do that, it's more weakly held in your brain and it will vanish. Okay, Sudarshan, if things went over your head, you should ask the questions. Okay, I will simplify if that happens. Okay, clients want to simplify the language, Ramya, in the MOU you drafted. Yeah, so that is very important. Great takeaway. I said that you have to remember the client's perspective, what kind of value they appreciate. Like everybody won't want a tier one lawyer drafting. Sometimes people want less technicality and more on the substance, less, they don't want so many quantitative and qualitative parts. They want only the broad stuff, right? Like a lot of times we sign rent agreements which are the regular 2-3 page rent agreements because that's what owners prefer. Then sometimes we want to add clauses on our own, but we keep the format the same, because when we tried changing that, people thought that we are hardcore corporate lawyers and they will not want to lease their premises to us. Okay, so that happens a lot. Yeah, so I think Ramya should bring your so did you get some takeaway from this session today, Ramya? Did you figure out some ways in which you could simplify your drafting? You can take some examples of clauses and we can do some practice exercises tomorrow. Okay, so looking for more people to share takeaways, and then start preparing to have a great start setting some goals from tomorrow. Like, what will you uh, what do you want to do from learning to draft your first commercial contract? How will this help you? If you learn to draft your first commercial contract, what can you achieve? Okay, would you want to start off freelancing? Would you like to work on the side for lawyers and law firms? What do you want to do? Would you like to help startups? Okay, some things you'll be able to identify. Some of you may want more briefing before you think of a goal, but just start to think, okay? Because this 24-hour period will help this idea germinate in your mind. Okay, so all right, everybody, have a great evening. If there are any questions, feel free to ask. Okay, else we close. Any questions you want me to look at?